In court judgment in the matter of KK and RS Sri Lanka and the Secretary of State for the Home Department.
Yes, live streamed oral judgments are something of a rarity, so I should emphasise to anyone following these proceedings on live stream, if there are any, that such judgments typically have some presentational rough edges, and the definitive version will appear as a corrected transcript on Bailey in due course. Right, I'll start the judgment. Introduction. On the 27th of May last year, the Upper Tribunal Immigration and Asylum Chamber, comprising Upper Tribunal judges Bloom, Rimington and Norton-Taylor, promulgated a country guidance decision in two appeals, KK and RS, concerning Sri Lankan Tamils who claim to have a well-founded fear of persecution if returned to Sri Lanka by reason of their political activities in this country, so-called SUR plus activities. For the transcriber, that's SUR, S-U-R, and plus, P-L-A-C-E. Although SUR plus activities are the principal focus of the decision, there's also a consideration of the principle in HJ Iran against the Secretary of State for the Home Department, 2011 UK SC 31, 2011 AC 596. The decision replaced the previous country guidance decision concerning returns to Sri Lanka, GJ and others, brackets post-Civil War, returnees, close brackets, Sri Lanka 2013 UK UT 00319. An appeal against GJ was rejected by this court in MP Sri Lanka against Secretary of State for the Home Department 2014 EWCA Civ 829. The Upper Tribunal reached its conclusions in the present case after hearing extensive evidence and submissions, and its reasons, which run to some 661 paragraphs, are full and careful. It upheld the appeals of both the individual appellants. I should at this point note that in both cases the appellant had failed in the First Tier Tribunal, but the Upper Tribunal had found an error of law and directed that the decision be remade by it. The Secretary of State sought permission to appeal against the Upper Tribunal's decision. Permission was sought from the Upper Tribunal itself, but was refused by Upper Tribunal Judge Norton-Taylor in a reasoned decision dated the 30th of June 2021. The application to this court has been directed to be determined at an oral hearing. Under CPR 52.5(2). Such applications in country guidance cases have in recent years always been determined at an oral hearing in accordance with observations of the then Vice President Maurice K. LJ in R brackets SG brackets Iraq close both brackets against Secretary of State for the Home Department 2012 EWCA Civ 940 2013 1 WLR 41. I will have something to say about those observations at the end of this judgment. The Secretary of State has been represented before us by Ms. Naina Patel and Ms. Holly Higgins, and the respondents by Mr. Alistair Mackenzie, Mr. Ali Bandegani, and Ms. Antonia Benfield. The counsel on both sides produced very helpful skeleton arguments, and I also wish to pay tribute to the care and accuracy of the pleading of the grounds of appeal, which is an art which is not as common as it should be. I think I should say at the outset that I would refuse permission to appeal. Since this is not a substantive appeal, I need not set out any of the background, and I can proceed directly to the grounds. 6 grounds are pleaded with various sub-grounds, but there is a degree of overlap between them, and rather than go through them one by one, I prefer to consider them under 4 heads. 1. Clarification / amendment. In 2 respects, the Upper Tribunal went beyond, to use a neutral term, the decision of the tribunal in GJ. First, in GJ, the principal group at risk if returned to Sri Lanka is defined as quotes, individuals who are or are perceived to be a threat to the integrity of Sri Lanka as a single state because they are or are perceived to have a significant role in relation to post-conflict Tamil separatism within the diaspora and or a renewal of hostilities within Sri Lanka. I'll just pause to say that I, for the first time, have noticed something wrong in the grammar of that statement. I wonder whether it's reproduced at the end of the decision. In any event, I will sort that out in the final version of the judgment. The paragraph is paragraph 356. 7 in brackets, little a in brackets. The reference to, quotes, a significant role in relation to post-conflict Tamil separatism within the diaspora, close quotes, is in practice a reference to surplus activities in support of Tamil separation. The tribunal in GJ did not offer any guidance on what constituted, quotes, a significant role, close quotes. The appellants, brackets, the respondents to this application, close brackets, argued that such guidance would be useful by way of clarification. The Secretary of State contended that clarification was unnecessary, and also that if it were to be given, it would constitute, quotes, amendment, close quotes, and should only be given if there were evidence of durable and well-established changes in the relevant circumstances, such as to justify amendment of a previous country guidance decision. In that respect, it relied on some observations at paragraph 72 of the decision of the Upper Tribunal, Mr. Justice Blake, the then President, presiding, in EM brackets returnees, close brackets, Zimbabwe, CG, 2011 UK UT 98 IAC. Those observations were quoted with apparent approval by Lord Justice Maurice Kay in MP. The tribunal preferred the respondent's submissions and devoted paragraphs 451 to 501 of its reasons to guidance about the correct approach to what constituted a, quote, significant role as that phrase had been used in GJ. It said that it regarded this guidance as, quotes, clarification, close quotes, not amendment, but it also said that if it was wrong about that, there had been sufficient change in Sri Lanka since the date of GJ to justify amendment in accordance with the approach prescribed by EM. Second, the tribunal in GJ said nothing about the correct application of the principle in HJ Iran in the context of the return of Tamils to Sri Lanka. The tribunal in this case believed that that question should be addressed, and it did so at paragraphs 537 to 555 of its decision. The Secretary of State wishes to argue on appeal that in both respects the Upper Tribunal made an error of law, because it was indeed in both respects amending the guidance in GJ, and no sufficient basis for doing so had been established. various aspects of this argument are the subjects of grounds 1A to 1C, 2A and 4A. In my view, the premise of this argument is misconceived. Mr. Justice Blake's observations in EM lay down no rule of law prescribing the circumstances in which the Upper Tribunal may promulgate country guidance which departs from or amends previous country guidance. It is, of course, the practice, for reasons which make obvious sense, that country guidance should only be revisited where strong reasons for doing so are shown, which will hopefully only be at infrequent intervals. But where the Tribunal decides that a fresh country guidance decision is required, which will be a decision involving where the Tribunal decides that fresh country guidance is required, which will be a decision involving the judges with specialist responsibility for the country in question, it must be free to give whatever guidance it believes will be useful and is justified by the evidence which it hears. It will generally, for good reasons, take the previous decision as its starting point. But there can be no rational basis for imposing artificial constraints on whether it can go beyond what was said in the previous decision, even if that can properly be characterised as amendment rather than clarification, though in fact the distinction between the two will often be impossible to apply in practice. As I understand it, Mr. Justice Blake himself made this very point in his later judgment in CM (EM Country Guidance Disclosure) Zimbabwe CG 2002-12 UK UT 00059 see paragraph 118. But whether that was the precise point he was making in that passage or not, it is in my view plainly the case. I of course accept that, as he says there, a tribunal altering the country guidance on the basis of a perceived reduction in the level of risk to returnees in the country in question will need to be satisfied that the change in question is durable, but that is a different point. I therefore see no arguable error of law in the tribunal's decision to offer guidance on the meaning of, quote, significant role, close quotes, or on the application of HJ Iran. Although, prudently, in view of the submissions made, it addressed the question whether there was sufficient, it addressed in the alternative the question whether there was sufficient justification for, quotes, amendment. That was, as a matter of law, an unnecessary exercise. I would add, generally, that I am not in the least surprised either that it was thought sensible to revisit GJ, since 7 years had passed since that was promulgated and there had been significant changes in Sri Lanka since then, or that it was thought useful to offer tribunals further guidance on the meaning of significant role and on the application of HJ Iran. Heading 2, Motivation. At paragraph 475 of its decision, the Upper Tribunal concludes that the objective of the government of Sri Lanka in relation to surplus activities by Tamils, it quotes, is to identify those who are an actual or perceived threat to the integrity of the Sri Lankan state by reason of their committed activism in pursuit of a separate Tamil state on the island of Sri Lanka, close quotes. It goes on to say that that is, quotes, the contextual prism through which the term, open quotes, significant role, close quotes, should be interpreted, close quotes. Between paras 476 and 499, it identifies a number of elements which would or would not be relevant to an assessment of whether an individual would be perceived by the government of Sri Lanka as playing a significant role, as so understood, by reason of their surplus activities. One of the factors which it considered as part of that exercise was the relevance of the applicant's motivation. That is, whether they took part in the activities in question because of a genuine commitment to Tamil separatism, or only because they wanted to give that appearance in order to found or support an asylum claim. That phenomenon of what have been described as opportunistic hangers-on, or people taking part in surplus activities, quotes, in bad faith, close quotes, has been considered in several authorities, in particular YB brackets Eritrea, close brackets, against Secretary of State for the Home Department, 2008 EWCA Civ 360, TL brackets Surplus Activities Risk, close brackets Burma, 2009 UK AIT 00017, KS brackets Burma, close brackets, against Secretary of State for the Home Department, 2013 EWCA Civ 67, and TS Burma, 2013 UK UT 000281 IAC. Sorry, that should be TS brackets Burma against the Secretary of State for the Home Department. It is clear that it is a question of fact whether a particular government is likely to try to distinguish between the sincere and the insincere activist so as to persecute the former but not the latter. And it is recognised that if the government in question is likely to make no such distinction, an asylum seeker may, however unpalatable this may be able to succeed in a claim based on surplus activities, even where those activities have been undertaken in bad faith. As regards that issue in the present case, the tribunal said at paragraph 494 of its reasons, quotes, in terms of the evaluative assessment of an individual's profile as it is reasonably likely to be perceived by GOSL, we agree with the appellant's submission that motivation, underlined, is not relevant. The reason for this lies within the previous sentence. The critical question is what the authorities will make of the activities in respect of which they have obtained information. They will have little or no inclination to inquire into an individual's good faith or lack thereof. We acknowledge that there must exist the possibility of opportunistic, quotes, hangers-on, close quotes, making out a claim for international protection. Unattractive as this may seem, it cannot act as a valid basis for rejecting a risk, end of quote. I should note at this point the tribunal's use of the phrase, open quotes, little or no inclination to inquire, underlining to inquire, close quotes. I will come back to that phrase later. The Secretary of State claims as her ground 2B that there was no proper evidential support for that finding. Paragraph 30 of the skeleton argument makes 3 points in that regard. First, at A, it is said that on the evidence, the government of Sri Lanka had the means to form a view about motivation because it had been found that it has found in GJ and accepted in the present case that it has sophisticated facilities for monitoring online and mobile phone communications of diaspora members and has a network of informers in the diaspora. It might be doubted how reliably those means would be able to distinguish insincere from sincere activists. But in any event, the essential point is that proof that the government of Sri Lanka has the means to make such an assessment is not evidence that it has the inclination to do so. Secondly, at B, it is said that potential returnees would typically have to undergo an interview at the High Commission in order to obtain temporary travel documents, and that if they were asked about whether they had separatist views, or more particularly about surplus activities in support of separatism, it was necessary to assume that they would give truthful answers. That is, that they would say that their participation in separatist activities had been insincere. It is said that the tribunal, quotes, failed sufficiently to consider why GOSL would pay no regard to such an answer, end of quote. There was in fact we were told that there was in fact no evidence about what questions were asked at such interviews. but even if it is reasonable to assume that in many or most cases questions would be asked about sur place activities, and that someone who had in fact been participating in them but doing so insincerely would say that they had been doing so insincerely, since it would be in their interest to do so, it does not follow that they would be believed. Indeed, it might reasonably be thought that the interviewer would be distinctly sceptical. I do not believe that it is arguable that the Upper Tribunal was obliged to attach weight to this factor, or even, assuming it was positively relied on at the hearing, to refer expressly to it. Thirdly, at C, the skeleton argument identifies some passages in parts of the Tribunal's findings addressing different issues to the effect that GOSL applies at least a degree of, quotes, qualitative assessment, close quotes, to information about involvement in separatist activity. That is no doubt the case. Indeed, for that very reason, the Tribunal rejected the appellant's contention that any but the most trivial involvement in sur place activities would meet the necessary threshold of risk. But I do not regard those findings as inconsistent with the finding that the government would have no inclination to inquire into the sincerity of a person participating in sur place activities. It must be recalled that the question only arises where a person is known to have taken part in activities which, by reference to the other factors specified by the Tribunal, including the nature, extent and duration of the activities, show them playing a significant role in separatist activity in the sense glossed by the Tribunal at paragraph 475. If a person's activities pass that threshold, it is not difficult to see that the government of Sri Lanka might not wish to take the trouble of trying to ascertain how sincere they were. And in any event, that was a conclusion which the Tribunal was unarguably entitled to reach. At paragraph 13 of the Secretary of State's skeleton, 30 of the Secretary of State's skeleton argument, it is argued that even apart from those points, paragraph 494, paragraph 494 of the decision is too widely expressed, and this was an aspect which Ms. Patel emphasised in her oral submissions. She pointed out that the government of Sri Lanka She pointed out that even if the government of Sri Lanka had no inclination to inquire into the motivation of a particular person who had been taking part in separatist activities, it did not follow that it would ignore evidence of insincere motivation of which it was otherwise aware. Yet the Tribunal says, without qualification, that, quotes, motivation is not relevant, close quotes. However, I do not believe that that is a fair reading of what the Tribunal was saying. The paragraph must be read as a whole. It is, in my view, unarguably clear, in particular from the third sentence, that the essential point being made is that if the government has information about a person's involvement in sur place activities, meeting the necessary threshold, it will have no inclination to seek to go behind that information and inquire into, underlining the phrase inquire into, whether it was really sincere. The Tribunal was not saying that the government of Sri Lanka would in no circumstances have regard to evidence that such information was insincere when it was otherwise aware of it. One example canvassed in argument before us was where the person in question was in fact an informer or agent who was taking part in separatist activities to the government's knowledge in order to obtain information about others or to maintain their cover. Plainly, the Tribunal did not mean to say that such a person would be at risk of persecution on return because of their participation in those activities. That is an extreme case, but there could no doubt be other cases where the Sri Lankan government would become aware without itself initiating inquiries, that a person's involvement was insincere. And paragraph 494, to my mind, quite clearly does not mean that evidence that that was the case would be irrelevant. That is, in my view, apparent on a fair reading of the decision, but it is in fact confirmed by paragraph 19 of Judge Norton Taylor's reasons for refusing permission to appeal, where he said, quotes, "The panel did not discount or in any way exclude the relevance GOSL might place on information going to an individual's motivation, which was," quotes, "otherwise apparent," close quotes. "Nothing in the decision precludes taking into account evidence obtained which might indicate to GOSL that the individual concerned might have undertaken activities in bad faith," end of quote. I would finally note that at para 501 of its decision, the Upper Tribunal said, quotes, "The guidance we have provided is just that. The assessment to be undertaken in any given case is always fact-specific, and there may be exceptional scenarios which fall wholly or partially outside the parameters of our analysis. That is entirely," end of quote, "that is entirely correct and could have particular application in the context of the motivation question." 3. Risk of detention for expressing separatist views. The effect of the decision in HJ Iran, as applied in the context of political opinion by RT Zimbabwe against Secretary of State for the Home Department 2012 UK SC 38 2013 1AC 532 is well known. I can sufficiently summarise it for present purposes as being that if a person would be persecuted on return for the manifestation of their political opinions, it is no answer to say that they could avoid persecution by concealing those opinions. Accordingly, if it is found that but for the threat of persecution they would manifest those opinions, they are entitled to international protection. Ms. Patel reminded us of what Lord Dyson said at paragraph 50 of his judgment in RT about the relevance of whether the expression of a belief lay at the core or the margin of the right in question, but that is not a relevant point for present purposes. It was the Secretary of State's case in the Upper Tribunal that not every expression of separatist views by a returnee to Sri Lanka would be likely to lead to detention or therefore persecution. The government of Sri Lanka would, it was submitted, make a, quotes, qualitative assessment, close quotes, of the significance of what had been said, as the tribunal had found it would in the case of surplus activities. It was reasonable to suppose that it would take the same approach to activities in support of separatism, whether in the UK or in Sri Lanka. The tribunal did not accept that submission. At paragraph 552 of its reasons, it found that if a person who was returned to Sri Lanka did express Tamil separatist views and that were to become known, it was reasonably likely that they would be detained. I should say that it is common ground that detention was effectively the gateway to a risk of persecution. That finding was based at least partly on contextual factors itemised in para 547 of the reasons. The tribunal made it clear that it did not accept that activity in Sri Lanka would necessarily be treated in the same way as activity in the UK. By ground 4b, the Secretary of State contends that that finding was not reasonably supported by the evidence. I do not believe that that is arguable. There was explicit evidence that separatist political activities in Sri Lanka would not be tolerated at all. See, for example, paras 53, 94 and 109 of the reasons. The tribunal reviewed all of the evidence about the attitude of the Sri Lankan government to separatism and concluded explicitly at paragraph 349, quote, drawing all of the above together, we conclude as follows. The core focus of GOSL is to prevent any potential resurgence of a separatist movement within Sri Lanka, which has as its ultimate goal the establishment of Tamil Eelam. GOSL draws no material distinction between, on the one hand, the avowedly violent I think I can stop at Tamil Eelam, ... whilst there is currently limited space for pro-Tamil political organisations to operate within Sri Lanka, there is no tolerance of the expression of any avowedly separatist or perceived separatist beliefs. End of quote. The tribunal therefore made a clear distinction between pro-Tamil activity and activity which was avowedly separatist. The tribunal, they conclude that the conclusion at the end of that paragraph is clearly based on the evidence which the tribunal had considered overall. At paragraph 46 of her skeleton argument, the Secretary of State makes three particular points in support of her of this ground. First, she points to three pieces of evidence which she says show a degree of tolerance by the Sri Lankan government of expressions of separatist opinion in Sri Lanka. All three refer to public commemorations taking place for Tamils who had died fighting for the LTTE, sometimes referred to as heroes or martyrs. The only one of the pieces of evidence says in terms that those commemorations had in recent years been tolerated, although they were monitored by the authorities. That is not, however, the same as tolerating explicit expressions of support for separatism. And I do not consider it arguable that it undermines the tribunal's conclusion to which I have referred. Ms. Patel submitted that that material should at least have been addressed by the Upper Tribunal, particularly since it was contrary to the evidence of one of the expert witnesses whose evidence had been recorded, to the effect that such commemorations of people who had died in the Civil War, sort of Tamils who had died in the Civil War, would not be tolerated. Sorry, I'll start again. Such commemorations of LTTE fighters would not be tolerated in Sri Lanka. But since the evidence carries no real weight for the reason no real weight as regards the essential issue for the reason I have given, even if it is correct, I do not accept the submission that the tribunal was obliged to refer to it. Second, the skeleton argument refers to a statement at paragraph 550 of the reasons. That quotes, whilst diaspora activities are clearly a source of hostility on the part of GOSL, the manifestation of separatist beliefs within Sri Lanka itself is highly likely to attract adverse attention and may, depending on the facts of the case, require less from an individual to prove that they would be detained. The Secretary of State's argument is that the tribunal's reference to, quotes, depending on the facts of the case, necessarily involves an acceptance that there would be a qualitative assessment of the significance of expressions of separatist opinion in both Sri Lanka and the UK. I do not accept that. To me, the plain meaning of the passage is that the tribunal believed that the kind of qualitative assessment that would be applied to the expression of separatist opinion in the UK would not be applied in Sri Lanka. It was, as per its finding at paragraph 552, reasonably likely that in the latter case it would lead to detention. Third, she comments on a different observation in paragraph 550 to the effect that, quotes, the respondent's position appears to require an individual who would already be at risk on return under paragraph 3567A of GJ to then undertake yet further activities so as to replicate the same risk. I confess to finding that point rather opaque, and I do not believe it is central to the tribunal's reasoning. But in any event, the Secretary of State's only comment on it in her skeleton is that it is, quotes, plausible that the government of Sri Lanka employs consistent risk-based assessments of threat, quotes, across the board, close quotes. That goes nowhere. In one sense, the point may be obviously true, but there is nothing surprising in the Sri Lankan government taking the view that pro-separatist activity at a given level in Sri Lanka poses a greater risk than a history of such activity at the same level in the UK. That is what the Upper Tribunal found, and that finding was, in my view, plainly open to it. At paragraph 47 of her skeleton argument, the Secretary of State contends that the contextual factors relied on in paragraph 547 of the reasons are incapable of rationally supporting the finding at paragraph 552. 4 particular pieces of evidence are relied on, but none in my mind is capable of undermining the tribunal's conclusion. The first is that the tribunal in GJ did not go quite as far as the tribunal did in this case. That, however, is immaterial, since the tribunal in GJ did not consider the application of HJ Iran at all. The second addresses the tribunal's statement that quotes, Dr. Nadaraja's evidence to us, upon which we attach significant weight, is that individuals would be at risk if they sought to undertake activities in Sri Lanka that they pursued in the United Kingdom, and that there was, quotes, zero, close quotes, possibility of any organisation with an avowedly separatist agenda being able to operate in that country, end of quote. It is said that that refers only to the same activities as in the UK, many of which would probably be impossible in Sri Lanka anyway. But I cannot see how that undermines the tribunal's point, which is the broader one that the GOSL regards Tamil separatist activities with extreme hostility. The third is that there was evidence of what the skeleton argument calls, open quotes, expression of separatist beliefs through commemorative events and or demonstrations, close quotes. I have already made the point that the events in question cannot be equated with direct expressions of separatist belief. The fourth refers to the evidence of a witness who was a British citizen who had tried to open an office in Sri Lanka for an organisation which advocates Tamil separatism. It is said that his evidence shows that although the office had been closed down by the Sri Lankan CID, the staff had not been detained. In fact, the passage in question is to the effect that the CID said that, quotes, the people there, close quotes, should go home, or they would, quotes, be taken with the CID, close quotes. It's unclear who the people in question were or what they had done or said, and in any event, it's hardly particularly encouraging that they were threatened with detention. But the real point is that the somewhat equivocal evidence of a single incident of this kind cannot undermine the tribunal's factual conclusion based on a careful overall assessment. In truth, all these types of point are examples of so-called, quotes, island hopping. Close quotes. A viable appeal cannot be maintained by pointing to this or that snippet of evidence or argument and complaining that it is inconsistent with the tribunal's conclusion or has not been properly addressed, where the tribunal has given clear and cogent reasons for the conclusions which it has in fact reached. The decision of the Upper Tribunal in this case is conspicuously thorough and cogent, and none of the points of detail raised by the Secretary of State would have, in my judgment, any prospect of undermining those conclusions. Heading 4, the individual cases. The Tribunal found, in the case of both the individual appellants, both that they had participated in sur place activities in a way which passed the, quote, significant role, close quotes, threshold, as explained by it, and that they would, if returned to Sri Lanka, wish, but for the threat of persecution, to express their separatist opinions, i.e. the HJ Iran ground. In both cases, and in both respects, it acknowledged that its decision was not straightforward, not least because not only because the FTT had made adverse findings about the credibility of, the First Tier Tribunal had made adverse findings about the credibility of both appellants. However, it gave careful and fully articulated reasons for coming to the conclusions that it did, notwithstanding the various problems about the evidence. By grounds 3, 5, and 6, the Secretary of State contends that the Tribunal's conclusions in each case, and as regards both the significant role and HJ Iran points, betray errors of law. To some extent, the grounds follow from the generic grounds which I have already considered, but there are also challenges on the basis that the Tribunal's particular findings of fact in each case were not rationally open to it on the evidence. To the extent that the challenges in the individual cases track the generic grounds, I need say nothing more about them. That is the case as regards ground 5. To the extent that they depend on challenges to the Tribunal's fact-finding, on the face of it, they cannot be pursued because this is a second appeal governed by CPR 52.7, and the individual grounds raise no important point of principle or practice, and there is no compelling reason for this court to hear them if the generic grounds are not going to proceed. However, Ms. Patel reminded us that a more flexible approach to the second appeal test is appropriate in cases where the applicant succeeded in the First Tier Tribunal and has not had the chance of an appeal against of a previous appeal against the findings in the remade decision. See J.D. Congo against Secretary of State for the Home Department, 2012, EWCA Civ 327, 2012 1 WLR 3273 at paragraphs 28 to 32. I accept that point, even though this was a decision by an unusually experienced tribunal with a small t, comprising a panel of 3 Upper Tribunal judges. I consider it right to consider the merits of those grounds, though I do not think it is appropriate to address them individually, as might be necessary if the only issue were whether they had a real prospect of success. In my judgment, none of the grounds in question has a real prospect of success. They focus on a series of individual weaknesses in the appellant's cases before the tribunal, about the extent of their involvement in separatist activities in this country, round 3, and about the genuineness of their belief in Tamil separatism, and relatedly whether they would wish to express separatist beliefs if returned, ground 6. But the weaknesses in question are all points to which the tribunal itself acknowledged and which it specifically addressed in its reasons. I see no real prospect that this court would find that the conclusions which it reached were not open to it. Procedural postscript. At paragraphs 76 to 77 of his judgment in SG Iraq, to which I referred at the beginning of this judgment, Lord Justice Maurice Kay expressed concern that where an application for permission to appeal was made in a country guidance case, there could be serious delay before the application was determined, and if permission were given, the appeal was heard. That was obviously particularly undesirable in the case of a country guidance appeal because of the fact that because so many cases in the First Tier Tribunal would have to await the outcome of any such application or appeal. Part of the potential for delay arose from the fact that under the rules as they then stood, if the application were refused on the papers, the applicant would have the opportunity to require an oral hearing. In the state of the Court of Appeal lists as they were in those days, that could typically involve a delay of very many months. In order to obviate that risk, Lord Justice Maurice Kay said that thenceforward all applications for permission to appeal in country guidance cases would be listed for an early oral hearing on notice to the respondent without first being considered on the papers. Since then, the rules governing applications for permission to appeal have changed. There is no right to renew an application which was refused on the papers at an oral hearing, and an oral hearing can only be directed if, exceptionally, the Lord or Lady Justice considering the application on the papers so directs. It is not, therefore, appropriate for there to be any automatic rule. I should also say that, at least for the time being, there is no problem about dealing with applications expeditiously. The practice, as stated by Lord Justice Maurice Kay, therefore requires some modification. Applications for permission to appeal in country guidance cases should continue to be treated expeditiously, but they will be considered on the papers by a Lord or Lady Justice as required by CPR 52.51. It will be for them to consider whether an oral hearing is required in accordance with paragraph 2 of the rule, and there will be no presumption in favour of such a hearing. Having said that, the special nature of a country guidance appeal is such that I would expect that in many or most cases, such a hearing with the respondent directed to attend will be regarded as the most appropriate way of dealing with the application. Conclusion. I would, as I have said, refuse permission to appeal. I would give permission for this decision to be relied on in subsequent proceedings, to be referred to in subsequent proceedings, partly because of the question addressed in the procedural postscript, and partly also because it is possible that tribunals may find what I have said about the motivation issue useful, although I repeat that what I have said does no more than identify what, in my view, the Upper Tribunal itself was saying. That point apart, however, the latter point apart, however, there should be no need to refer to this decision. I have only addressed the particular points raised by the application for permission to appeal, which covers by no means the whole of the issues decided. And even on those, it has not been necessary for me to attempt any comprehensive summary of the Upper Tribunal's reasoning. It is to the decision of the Upper Tribunal that future tribunal, that the First Tier Tribunal should refer.
I agree that the application for permission should be dismissed for the reasons given by my Lord. I would hope that the judgment delivered by my Lord will clear up any potential for misunderstanding of what the Upper Tribunal was saying on the question of motivation.
My Lord, my Lady, I'm grateful. May I seek our costs, which I believe we're entitled to under the practice direction, having been directed to attend?
Yes. Have you exchanged a summary?
We have not, no, my Lord.
You've got a problem then, haven't you? Why haven't you?
Because of the short notice and because it slipped on.
No short notice. You might have expected a decision yesterday afternoon. The practice is that before any hearing, which is likely to last less than a day, a summary of costs must be exchanged by both parties 24 hours before. Did the Secretary of State serve hers on you?
No, neither side did, as far as I'm aware.
Well, that helps you, I think, then. No problem about the principle. Is there, Ms. Patel?
There's one issue with the principle, which is I think the practice direction is if the court directs the respondent to file submissions or to attend a hearing, it will normally award costs to the respondent if permission is refused. And of course, the normal position is that the skeleton that's filed is the 3-page statement. And the respondent in this case...
Sorry, will you take your mask off? I can't...
I'm so sorry. I keep
It's rather blurring what you were saying.
So the rule is that the costs follow where the respondent is directed to both file submissions and to attend. There's no issue that the respondent was directed to attend. But the lengthy skeleton that was received at the start of the month was, I think, volunteered by the other side. So we would...
Is that right? I have seen an exchange of emails in which I think Solicitor for JCWI asked whether, I think it was asked whether the court would be assisted.
No, that's fair, my lord.
And the answer from the court was, please file within 14 days.
If you'd like to file it by this date, I think was the answer.
And now unless you want to take a very technical point, which you're free to take, that isn't a direction, I think anyone reasonable on their side would think that they had been asked to do a skeleton.
Well, that's my submission, my lord, is that normally it would be the cost.
Well, I think that's my answer to it, but I shouldn't ask.
And then, of course, there's the practical problem, which is that we don't...
yes, well, that is more of a problem. I mean, I'll speak to my lady at the moment, in a moment.
And we obviously didn't file one because in this situation, we would be unlikely to be seeking our costs, and if permission had been granted.
No, that's a fair point.
So it was something that we turned our minds to, but
so
I'm not sure that does assist my.
What are you submitting the position should be?
Well, it would seem as though there are two options, my lord. One is not to award the costs because there is no statement. And the only other option I would have thought is detailed assessment, which seems terribly disproportionate for a 2-hour.
Well, I suppose there is a third one, which I'm not saying we will do, but which is that a cost statement could be could be filed now, and we would deal with it on the papers. You can make any observation on the papers, and we would decide on the papers. It's not very satisfactory, and speaking for myself, I wouldn't be minded to allow the costs of that exercise to the respondent, because otherwise we could have dealt with it all at the hearing for no additional cost.
Well, that's what's unsatisfactory about it, is that it puts my client to further cost, which is not of our making.
I do see that, but then so would a summary, so would an assessment. So
I can have my choice. My lord, is that what you're saying?
Well,
could we have our costs of responding to the statement? I mean, it may be that we reach agreement, but if it's necessary to put in any short submissions.
Right. Well, I think I see where we are. Any more you want to say, Mr.
No. I mean, I
We'll-
apologise for
we'll,
the oversight on our side.
Just
Authorised